criminal justice system. I come to this topic
Roger is testifying on TV before Congress
under the Federal Criminal Code,
on C-SPAN
and as an attorney who has defended individuals and corporations charged under statutes in the code, and as a legal scholar who has dedicated much of his work to the improvement of our nation's laws and the justice system. And members of this task force have been instrumental in exposing and responding to the deficiencies of the Federal Criminal Code. Of course, Chairman Sensenbrenner has introduced the Criminal Code Modernization and Simplification Act. In addition, Mr. Scott, when he was chairman of the Subcommittee on Crime, Terrorism, and Homeland Security, held hearings soliciting views and concerns regarding the state of the Federal Criminal Code. And many well-respected commentators have criticized the Federal Criminal Code for its excessive length, lack of organization, redundant provisions, and outdated offenses. There also have been calls for certain substantive changes to the code, such as the bolstering of mens rea requirements, the decriminalization of some regulatory and other offenses, and the reduction in the number of mandatory minimum sentences. And many of these and other critiques are quite persuasive, and there's no doubt that most observers would agree that the Federal Criminal Code is in need of reform. However, before we contemplate how Congress might best streamline, reorganize, refine, and modernize the Federal Criminal Code, it's essential to draw lessons from past efforts. The seeds of serious modern-day efforts at comprehensive code reform, federal code reform, were sown in the 1950s and early 1960s by the American Law Institute's Model Penal Code, which with its technical precision, elegant organization and draftsmanship, and its attention to principles of culpability and mens rea, spurred many states to undertake significant revisions of their criminal codes. With the Model Penal Code and President Johnson's 1965 Crime Commission as a backdrop, Congress established in 1966 the National Commission on the Reform of Federal Criminal Laws, commonly known as the Brown Commission. The 1971 final report of the Brown Commission proposed a new federal criminal code, and this proposed code included a general part that set out definitions, defenses, principles for liability, and general standards for the exercise of federal criminal jurisdiction. The proposed code also featured a special part containing a comprehensive collection of all federal felony offenses. Despite the Brown Commission's tremendous efforts over 4 years, however, the proposed comprehensive federal criminal code never was enacted into law, although there were repeated attempts in the House and the Senate over a period of almost 12 years. So it may be time to revisit federal criminal code reform, and to be sure, many of the challenges that face Congress